Ladies and gentlemen, thank you for taking the time to be with us today and welcome to the M&A Academy program and our last webinar in the program. I sincerely apologize for the delay in getting this kick-started. My name is Nidhi Kelawala and I am a partner in the firm's corporate and commercial practice. I would like to extend a very warm welcome to this webinar to every one of you, whether you are in our audience in India or around the world. Next slide, please. The M&A Academy program is designed to provide foundational legal knowledge and understanding on M&A transactions and processes to corporate executives, in-house legal teams, and others participating or interested in M&A in India today. Our subject today is competition law issues in M&A transactions. On this slide is the agenda for today's webinar. In summary, we will have a presentation followed by a Q&A session with audience questions. We've already received several audience questions, but if you do have more questions, please submit them using the facility provided in the webinar portal. If we cannot cover all questions today, then we will be sure to respond offline by email after the webinar. Also, please note that a copy of the presentation, summary notes of today's discussion, and a recording of this webinar will be sent to you as a matter of course post completion of the webinar today. M&A is an important part of our firm's practice with more than 50 partners dedicated to this area because India is experiencing massive growth in M&A transactions. The topic for this webinar is extremely important in the Indian M&A landscape as competition law plays a vital role in M&A deals. Anyone interested in M&A in India today must have a thorough understanding of competition law issues to ensure compliance, mitigate risks, and facilitate seamless deal execution in India. In India, obtaining the approval of the Competition Commission of India is a critical step in an M&A process. This approval must be sought prior to consummation of the transaction, and specifically, parties involved in a merger, acquisition, or a joint venture must notify the CCI in certain instances, as we will deal with in greater detail through the course of this webinar. Failure to obtain this prior approval can also result in penalties, including fines, oftentimes invalidation of a transaction, and also reputational damage. It is therefore important for you to better understand this space, which of course is our objective today. Next slide, please. Everyone who has registered for this webinar should have received by email already a summary of the presenter and her credentials to talk about this topic today. So I will not spend much time introducing her. Suffice to say that Anisha is an expert on this subject and is qualified to express her views and opinions on competition law issues in M&A transactions. Anisha Chand is a partner in our antitrust and competition team and will be speaking to you today about some of the aspects I just discussed in greater detail. Over to you, Anisha, and thank you so much for being with us here today.
Thank you, Nidhi. A very good afternoon to everyone. I'm delighted to welcome you to this session where we intend to explore the critical interplay, as Nidhi said, between M&A or really deal making and competition law in India. The regulatory landscape, as you would know, particularly in the context of what the Competition Commission of India has been doing, it plays a pivotal role in shaping transactions today. And understanding this, therefore, is very crucial for seamless deal execution and closing. So what I intend to do in this webinar is to really address key questions that routinely come up in the context of M&A deals or joint ventures, including when does your deal require a prior approval from the Competition Commission of India, what exemptions might apply to your transaction, if at all, if there is a filing that is necessary, how should you approach the CCI, when should you approach the CCI, are there any risks of non-compliance, and generally speaking, how active the regulator in India is. So I intend to break down some of these aspects and explore all of its different facets and evolving facets and discuss certain practical strategies to help you navigate the process more effectively to ensure that your CCI approval journey is fairly smooth. I look forward to an engaging session and hope this discussion really adds value to your deal making efforts in India. Next slide, please. So here are some of the questions, like I mentioned, that we are going to be covering. And with that, I think we can just straight dive in. Next slide, please. So I think the first and foremost question is, who is the Competition Commission of India, and what is its role? Next slide. So the Competition Commission of India, as some of you would know, it has been set up as a sector neutral regulatory body whose job is really to prevent anti-competitive practices in the territory of India. And in the context of deal making or M&A transactions, its role is to actually do a screening to make sure that it is approving only those transactions which don't have any competitive or have any significant competitive harm on the Indian market. So the CCI's role is to review M&A transactions to avoid any competitive concerns, and mergers and acquisitions which breach certain predetermined and objective criteria based on assets and turnover thresholds or the value of your consideration is really the metric that is used by the CCI to make sure that it is only reviewing high value deals which truly potentially have an impact on the Indian market. So this is the regulator that you need to go to. And if you're doing a deal, let's say in a more regulated sector where you do have a sector specialist regulator, it is possible that your deal may require an approval, let's say from the IRDA in case it's an insurance deal, or an RBI. And in addition to that, the CCI, being the sector regulator, competition regulator, may also require an approval. Next slide, please. So when do I think the first and foremost question is, when do I need to notify the commission about my transaction? The answer is, next slide. So there are two ways in which you need to assess your transactions to see whether it needs a CCI approval or not. The first is to look at the conventional assets and turnover thresholds. You can move to the next slide, please. So, if the parties to the transaction breach certain objective thresholds, which are based on certain assets and turnover, which is very well stipulated in the law, then you need to take a prior approval from the commission, assuming that you're not eligible for any further exemptions. I'm sorry, my screen is frozen, but can you please move to the next slide? Yes, thank you. So like I said, there are assets and turnover based thresholds, and these are in the form, these are conventional thresholds, which we call target exemption, small target exemption thresholds, and certain jurisdictional thresholds, which are set out under Section 5 of the Competition Act. These are based on certain assets and turnover of the parties to the transaction. The small target exemption is to be tested only against the assets and turnover of the target entity whose shares, voting rights, assets, or control is being acquired. And if you meet the small target exemption, that means you are under those thresholds, and we'll talk about that on the next slide. Then you don't need to notify the transaction. But if you breach these thresholds, small target exemption thresholds, then there are certain thresholds where both the parties have to look at their assets and turnover to see on a combined basis if they're breaching those thresholds, and they can be complex. They're based on the enterprise assets and turnover, and also the group assets and turnover, which also include an India component and a worldwide component. So these can be very complex, and there are 8 such thresholds which need to be tested. If you meet any such thresholds, then you need to take approval from the commission. And the new kid on the block is the deal value threshold. It's been introduced effective 10 September 2024. And this is an interesting one because there is history to why this threshold was introduced. It was really to screen large tech mergers which were otherwise escaping scrutiny, because a number of these deals where large tech companies were involved didn't have the asset conventional, which they were not meeting the conventional asset and turnover threshold. So which is why the deal value threshold has come into existence, and we are yet to see how that pans out. But very quickly to tell you what DVT is, if the deal consideration that you're paying for your M&A deal or for your joint venture deal, for your mergers and acquisitions. If your deal value is more than 2,000 crores, which is roughly around USD 240 million, and the target entity whose shares, assets, or voting rights or control is being acquired has substantial India operations, then you meet this threshold and you need a prior approval from the Competition Commission of India. Now, the substantial business operations test is also local nexus test to see even if you have a large deal, but it doesn't have any impact in the Indian market, then you probably don't need to notify that. And there are two sorts of tests. One is designed for digital entities, the other for non-digital entities. So if you are a digital entity or you're providing digital services, then there is a user-based test, there is a gross merchandise value test, and there is a turnover test. And if you meet either of these three tests, then you meet the local nexus criteria and you need a prior approval from the CCI. So the user-based criteria says that if in a global deal, if 10% or more of users of the target entity are from India, then you need to notify and you need to take prior approval. Similarly, if more than 10% of your GMV is from India, or more than 10% of your turnover is from India, then you satisfy the SBOI test, a substantial India operations test, and you need a prior clearance from the Indian Antitrust Authority. If you're a non-digital business, then you don't have the user-based criteria at all. You have the GMV criteria and the turnover criteria, but there's also an added minimum revenue or minimum GMV test. So your revenues or your GMV needs to be more than 10% from India, plus it needs to have, the target entity needs to have a minimum of 500 crores of GMV from India or the turnover India. So there's an added additional test which is quantifiable and which is linked to your revenue or GMV in case it's a non-digital entity. Next slide, please. So this is a sort of an interesting test. If you look at how deal value is to be computed, it is sort of a very wide scope. It includes all sorts of consideration, direct, indirect, deferred, immediate, cash. If you have an option which is contemplated in your agreement, the value of that option, any sort of agreements that you may be doing which are commercial in nature but that are ancillary to the transaction documents, then any sort of consideration that is payable under those agreements also needs to be included. So it's a very wide definition. In fact, the law says that if you're in doubt and if you cannot reasonably estimate what your value of the consideration would be, then might as well file and err on the side of caution. So as I mentioned, this DVT came into life very recently in September, 10th of September. We've had two cases, in fact, which have been filed in the last, ever since it got into force very recently. And the rest of the cases, and we'll probably look at the statistics in a while, rest of the cases are still being filed under the conventional asset and turnover based mechanism. But the immediate implication of deal value threshold was that even those transactions, so typically in any transaction which is notifiable and requires a prior clearance from the CCI, you need to take approval prior to any sort of consummation, even if it's a partial consummation. So you can't give an advance, you can't put your money in escrow, all of those restrictions apply to you and standstill apply to you. But when the DVT was introduced, because it was a new law, what the law very clearly stated is that if you have a partially consummated transaction, but you breach the deal value threshold, then you need to take approval for those parts of the transaction or those limbs of the transactions which haven't closed yet. And for the limbs that you have closed, of course, you need to tell me about it, but I will not penalize you. So that's a clarification that came in when the deal value threshold was introduced. And you know, some of the questions that time were that, oh, I did not take into account the CCI approval when I signed the transaction, so what will happen to my long stop date? So I think that sort of anxiety and all those questions have settled in because 2 months have passed. But really speaking, the fact that only 2 transactions so far have been filed under the deal value threshold mechanism means that it appears, at least prima facie, that it's not disrupting the transacting world in a manner that would have been the case if the legislation was interpreted too literally. Moving on. to the conventional, next slide please, to the conventional thresholds that now coexist with the deal value threshold. So as I mentioned, there is something called a small target exemption, which presupposes that if the target does not have a minimum asset of 450 crores or local revenues of 1250 crores, then it is not worthwhile for the commission to screen this transaction because the market impact is going to be minimal. So it's also called the de minimis exemption for that reason. And if your target entity, is not satisfying either of these criteria, or in other words, if both 450 and 1250 crores of assets and turnover in India are exceeded, then you need to, like I said, you're not eligible for the small target exemption, and then you need to see whether you meet the parties test or the group test, which I'm going to talk about in the next slide. Next slide, please. Now, the interesting part is that if you meet the deal value threshold, but you are otherwise eligible for small target exemption, you still need to notify under the deal value threshold regime. So these two tests are mutually exclusive. And now the assessment also for your deals have become a little more complex because you have to run two tests. One is under the deal value threshold test, and the other is the conventional assets and turnover test. So like I said, that if you don't get the benefit of the small target exemption, then there's a direct parties test where the purchaser and the target on a combined basis, but if they have, just to give you an example, assets of more than 2,500 crore, then you meet the direct parties asset threshold and you need to notify. Similarly, there are direct group tests involving the purchaser group and the target. Next slide, please. And there are also worldwide tests which have an India component. So if that is met, any of these fancy 8 tests basically are met, then you need a prior approval from the CCI. Next slide. So this is just sort of representative. I'm not going to take you through each of these, but the short point is that there are multiple tests that need to be run. So if these tests are met, are there any other exemptions that can potentially apply to my transaction? Can I still be excluded from taking a CCI approval? This is an often this sort of a question is asked, and the answer is yes. Even if you meet those objective criteria that we talked about, you can still avail certain exemptions. Some of the popular exemptions is something that we have on the next slide for you. If you can just move to the next slide. So the first is the ordinary course of business exemption. Now, this had a completely different connotation in the pre 10th September 2024 era, and this has come in a completely new avatar. So the OCB exemption, ordinary course of business exemption, is now specifically available for underwriters, stockbrokers, and mutual funds. If you're an underwriter or a stockbroker, and if you're acquiring less than 25%, you're eligible for the exemption. And even if you meet the different tests that we spoke about in the previous slides, you are exempt. You don't need a prior notification and prior approval from the commission. Similarly, if you're a mutual fund, as long as you're below 10%, you don't require any approval from the commission. The other very popular exemption, particularly in the private equity, venture capital community or investor community, is the solely as an investment exemption. If you're an investor who's a financial investor who's interested in making quick returns and moving on in life and giving those returns to their own investors, then this is an exemption which is very popular. So if a private equity or a VC fund is acquiring less than 25% shares voting rights without any acquisition of control, without any board representation rights, including a direct observer right, or the ability to access commercially sensitive information, potentially you can benefit from this exemption even if you otherwise breach those thresholds. If you're acquiring more than 10%, the assessment becomes a little more complex because you also have to look at the overlaps or business overlaps between the private equity fund, for example, and its portfolio companies, and map it against the business of the target companies. But despite all of its complexity, it's very specific in nature and it's easier to apply now. So you will be in the clear very quickly as to whether you're exempt or you're not. The third very popular exemption is a demerger exemption, which exempts share issuances by resultant companies in demergers where the shares issued are proportionate to the existing shareholding of the original company which has been demerged. Next slide, please. We also have a number of intra-group exemptions, for a lot of these group transactions, subsidiary folding into its parent companies to for various reasons. So that's sort of a very useful exemption that comes in handy. So any intragroup asset acquisition or a merger amalgamation is exempt provided there is no change of control, and ultimately, there is the control remains in the same hand. So you're sort of in those sort of intragroup restructurings or mergers amalgamations, this exemption, like I said, comes in very handy. There are also exemptions for creeping acquisition of shares and voting rights. So if you are already an existing shareholder, and if you hold shares between, let's say, 0 to 25% or 25 to 50%, so on and so forth, and you're not getting any incremental rights which improve the quality of the control that you have in the target, then you're likely eligible for these creeping acquisition exemptions. Next slide, please. So these are some illustrative or prominent exemptions that we often come across in deal making. And if you are entitled to benefit from this, then even if you meet those assets in turnover or deal value threshold, you can still be exempt. Now, if you're not eligible for any exemptions, and you've made peace with the fact that you need a prior approval for your transaction, how do I notify my transaction, right? So there are two popular formats. Next slide, please. One is the ordinary Form 1 approval route. It's sort of called the short form colloquially, but believe me, it's no longer short. It's fairly detailed, but it's also very streamlined. So most transactions are notified in Form 1. Form 1 is something that is typically applicable where the parties have certain business overlaps, but the overlaps, let's say in competing markets, is resulting in a market share which is less than 15%. That's when typically a Form 1 is filed. And lots of information on your transaction, explaining all the steps to the transaction, what is the structure, how's the control changing, what are the different markets in which the parties operate, where they overlap, what their market shares are, what is the general competitive landscape. These are the kind of details that you ordinarily need to provide in a Form 1. The long format is called a Form 2, where the market share of the parties in horizontal markets or competing markets is more than 15%, or where the overlaps in vertical markets is more than 25%. Vertical overlap is basically where the parties to the transaction are sitting and situated at different levels of the same supply chain. So a manufacturer and a distributor are vertically placed against each other. And if your combined market share in those vertical markets is more than 25%, then it is recommended that you file a Form 2. And there's just more information on markets that needs to be populated. For acquisitions, it is the onus of the purchaser to make the filing and take the approval under law. If it's a merger or amalgamation, all merging parties must jointly notify the commission and seek their approval. Now, typically, it is a binding agreement in case of an acquisition that is really seen as the trigger document to go to the CCI. If you don't have a binding agreement, if you're going, let's say, on a non-binding term sheet, your filing is not going to be accepted by the CCI. For mergers and amalgamation, your trigger document is the board resolution of the merging entities, which can serve as a good enough trigger based on which you can apply for the CCI approval. Next slide, please. Now, a related cousin of Form 1 is the Green Channel form, which is nothing but a Form 1 without market-facing information. So Green Channel route was introduced back in the day in August 2019. It is sort of innovative process so far as India is concerned. It's sort of an automatic deemed approval process. When you make the filing, there is no waiting period involved. You get a receipt or acknowledgement for your filing, and that's your approval. On that basis, you can go ahead and consummate your transaction. Now, Green Channel was designed with the idea that it's a fast track approval process, and for transactions where there are no business overlaps, you don't really need to have a waiting period of 30 to 60 days, and you can just directly file, get your approval, and like I said, close your transaction. So it's a form 1 without market information. I think the only challenge in a green channel is that you have to establish that the acquirer group and the target along with its affiliates don't have any sort of business overlaps, whether it's horizontal, vertical, or complementary. And there's a very broad-based definition of affiliates. So the entities with whom you need to map the business overlaps, that becomes very expansive if you look at the affiliate definition. So if, let's say, the target entity or the purchaser has 10% or more shares of voting rights in a company, or if it has less than 10% but has the ability to have some sort of board representation or have a veto right, that entity also needs to be considered for the purposes of mapping overlaps. If such purchaser or target entity has certain rights, which, let's say information rights, which are very intrusive in nature, which give it access to commercially sensitive information of the target entity, or any entity in question, that entity is also to be considered for the purposes of mapping business overlaps. And when you widen the expanse of entities which you need to map to be able to establish and demonstrate that you are worthy of green channel, it makes the process a little more um, cumbersome or onerous, and the possibility of you being able to claim a green channel legitimately, that also sort of reduces. Next slide, please. Now, the consequences of filing an incorrect green channel are also fairly high, because what that means is, because of the strict applicability of the green channel criteria, if you go wrong or if you file a green channel without consultation with the CCI in advance of filing the formal green channel notice, then you're exposing yourself to adverse consequences. So there can be penalties for filing an incorrect green channel if the commission is of the view that you were not eligible or there were some de minimis overlaps that were not correctly identified and prevented you from filing a green channel. Then you're just opening yourself and exposing yourself to certain penalties. We have seen two such cases which are publicly available, where the commission was of the view that green channel was incorrectly availed, and the parties had to refile, to seek their approval retrospectively, and they also face certain penalties. But this is more of a recent trend in the last 1.5 years. Before that, green channel were very popular, and the commission was also, I think personally, in a bit to improve its image to be seen as a more sector friendly or business friendly regulator, was also being fairly liberal in granting green channels. But there's been a slight shift in its sort of policy and decisional practice in the last 1.5 years. Next slide, please. So if you see, this was updated as of last week, but I have some numbers handy right now. This is as on today, we've got 111 filings. 22 notices currently are pending before the CCI for review. Out of these 111, we've got 84 notices which are filed in Form 1, Form 2, 11 notices, and we've got about 14 green channel filings. What you see on the screen is from last week, but I just sort of told you what the numbers as on the date of this webinar are. So this is what sort of the heat map looks like in terms of statistics. Next slide, please. And this also shows that Form 1s are more popular and mostly transactions are notified in Form 1. So the next obvious question is that if I do need an approval, and once I have filed with the Competition Commission of India, when should I expect my approval? What is the waiting period? So if you can just go to the next slide, I'll tell you what it looks like. The commission under the statute has 30 calendar days to come up with a prima facie view on whether the transaction poses any concerns, whether it requires a deep dive, and whether a phase 2, which is a more detailed investigation, needs to be undertaken. Now, typically 98% of the transactions get cleared in phase 1, including cases and transactions where the Commission has accepted certain modifications. We've seen in India only about there have been 1,200 cases or filings that the Commission has roughly analyzed and sort of reviewed in the last 12 years. And out of that, only 8 cases have gone into phase 2, which is a detailed investigation phase and can take almost a year to for the Commission to actually approve the transaction. But as you can see, an overwhelming number has been approved in phase 1. So the like I said, just going back to 30 calendar days is what the Commission has to come up with a view. But this 30 calendar days is not sacrosanct. It is not an absolute number. If the Commission has questions, it will issue you what we call a request for information. And the date on which this RFI is issued, the clock stops, and the period and the time period that you take to respond to that RFI fully is excluded from this 30 calendar day period. So typically for non-issues transactions, we see that within a month and a half to 2 months, approvals, are forthcoming. This is inclusive of the clock stop period. So when you're doing ordinary M&A deal where there are no concerns that your competition lawyers have alerted you to, then you should expect that about, in about 2 months, you should get your approval. Right? And this is assuming that those are unconditional orders. For Green Channel, the situation is very different. When you file is when you get your acknowledgement, and that's your approval order. But like I said, just be cautious when you're filing in Green Channel, because an incorrect Green Channel will mean that you will have to refile and you're exposing yourself to penalties. Next slide, please. So just I think segueing into something which is a little more substance oriented is that a number of times we see that a lot of deals are structured in with multiple steps involved. So there could be a restructuring piece followed by an investment, or there are multiple entities which are consolidating into one and then being acquired. So this is what we call interconnected transactions or multi-step transactions, which are happening, which are envisaged and conceived all together to facilitate a larger transaction. And from a CCI perspective, you need to make a single filing to make sure that you're taking approval for all the steps to that transaction, even if that individual step may not necessarily on a standalone basis trigger a CCI approval requirement. So let's just go through what the law says and what expression it uses. It says that where for a deal or for a transaction, the ultimate intended effect is achieved through a series of steps or smaller individual transactions, then a single notice covering all of these transactions needs to be notified to the Commission, and approval needs to be taken for all of these steps together. And any structuring which is done to avoid a CCI notification is something that the Commission will disregard. Its policy is always substance over form, so it will try and sort of pierce through the structural veil, metaphorically speaking, to see what the real intent of your transaction was and if the structuring was done to circumvent a CCI approval requirement. Next slide. There have been a number of cases also where interconnected transactions have faced, or non-notification of interconnected steps have faced the wrath of the Commission. There have been a lot of penalties in various cases which have been imposed by the CCI on large business conglomerates where like I said, there's been a premature consummation, or you've consummated one step of the transaction before seeking CCI approval, or waiting for CCI approval rather. So transactions which are intrinsically connected in intent and they're interdependent and one wouldn't happen but for the other are typically the sort of transactions which are interconnected, and interconnection can be established by the Commission through various means, including based on what your press releases state, what your internal documents state. And this is an important one because oftentimes there is resistance to take approval for certain steps in the transaction merely because they on its own don't really merit a CCI approval. So, but this is something to be cautious about. This continues to be on the radar of the Commission, and they don't have any qualms in calling for internal documents to verify whether what you're stating is actually true for themselves. Next slide, please. So again, a natural question is that if I don't need notify because there is a tearing hurry to close the deal, or if I've applied to the CCI but I've decided that I need to, for commercial exigencies, close my deal, and CCI approval can come in later, are there any consequences? Then the obvious answer is yes, there are consequences. Consequences are in the next slide, please. Consequences are in the form of civil fines. So if you look at just the law, so I think just one step before I tell you what the penalties are. If you close a transaction which where the CC approval is still pending, or if you've prematurely closed a transaction, or you've not notified the transaction at all, it is something that we call jumping the gun. So any action which is taken towards implementation of the transaction before CC approval, or like I said, complete non-notification of the transaction, or if you've exchanged or started premature integration, you've exchanged a lot of commercially sensitive information, and you've taken steps to consummate the transaction. All of these together are largely called gun jumping issues, and they can expose you to penalties. Next slide, please. The CISA has passed a number of gun jumping orders. We have seen that there's a rise in the number of cases that the Commission has been looking out for, and the quantum of penalty has also increased over a period of time. At one point in time, the Commission was fairly lenient, and the penalty figures were much smaller, around 5 to 10 lakhs, but increasingly we are seeing that there is a surge in the quantum of penalty, and also the number of cases where penalties are imposed. So if it's a gun jumping issue where it's a failure to notify altogether, or it's a gun jumping or premature consummation issue, the CCI can impose a penalty up to which can be as high as 1% of the total turnover or assets, or the transaction value, whichever is higher. As you could have guessed already, transaction value is a new insertion to bring it in parity with the deal value threshold. In the previous avatar, it was just 1% of total turnover or assets, but now transaction value has been consciously introduced to sync it up with the deal value threshold. So if you can see, the statute imposes or prescribes really high penalties, but in the last 1 to 2 years, you've seen a maximum penalty of 1 crore being imposed. Um, in addition to that, if you're making any false statement in your merger notice, or there is any suppression of material information, then the minimum penalty is 50 lakhs and the maximum can be 5 crores. Has this provision been used ever? Yes, the provision has been used at least twice, if not more. One was involving a case of Amazon. In the future coupons deal, where the Commission had for the first time invoked this provision, and there's also been another penalty involving large private equity players where Commission has imposed 50 lakh penalty for filing a incorrect green channel, making a false declaration, and also suppressing some material information. So, like I said, these are the sort of trends. And in the Amazon case, 200 crore penalty, 202 crore penalty was imposed, which is the highest in the context of merger control, where the Commission not only imposed the penalty, but they asked also to re-notify the deal with correct information, and the previous order was sort of kept in abeyance until the fresh filing is sort of made. So there are hard consequences, and like Nidhi said in the beginning, these are civil fines. There's a lot of reputational loss, and there's also invalidation. If you don't give complete information to the CCI, your filing will be rejected, it will be invalidated, and you need to then refile for approval, and your 30-day clock that we discussed in terms of approval timelines, that is going to restart. So it's generally better that you where you have determined that the CCI filing is required, you start in advance so that you're giving a comprehensive filing set to the commission. It is a well thought out draft, and all of these small steps will ensure that you have a smooth journey with the commission, and you're sort of prepared to deal with the regulatory questions that can be posed to you from time to time. So these are certain things that we've put together based on our experience. All of these are practical tips to help you navigate the maze that CC approval can sometimes be. But if you prepare in advance and you have the right set of advisors, it can be a much more smoother, easier process. So the first thing is that where your deal requires multiple approvals from multiple regulators, it is important that you ensure consistency in all submissions. uh, it's very, very important that your internal documentation is singing the same tale and telling the same story as what you've told your regulators. There cannot be any sort of disparity. um, if you are a large business house and have had multiple encounters with antitrust authorities in different parts of the world, then you may want to streamline, your positions that you've taken before different regulators to make sure that you're not taking different positions or different stance before different regulators, unless the law itself of that country requires you to alter your position. Now, as I mentioned, that the CCI is big on intent, and it wants to make sure that the strategic rationale that you have stated in the merger filing also aligns with what you're telling the world. Substance over form remains the thumb rule, as I mentioned before, in the context of interconnected transactions. So, structuring deals to evade a CC approval is not something that is seen leniently by the Commission. They want to be taken seriously, and right, like any regulator, and the kind of decisions that they are coming up with, whether it is purely approval decisions or it is penalty decision, you can see their expression of their expression of their assessment, and the richness of their orders is something that the world is talking about now. And as I mentioned, that your disclosures need to be complete, they need to be in sync with what your transaction documents say. They need to be You need to be fully transparent with the regulator. And if you're not giving sufficient information based on what the CCI has also what the CCI has come up with recently, its notes or guidance notes to how you need to write your form or your merger notice. If you don't comply with those notes, which they take very seriously, you can risk an invalidation, and that's not a good outcome, because your closing timelines can completely go out of whack, and your long stop date again can be again held to ransom. Now, some of the more recent things that we are witnessing is, because the workload of the commission has increased a little bit with the deal value threshold coming in, and because there are a lot of pre-filing consultations that you can do with the commission to seek their opinion on various matters, especially on evolving regulatory landscape. The CISA is taking a little longer to respond to some of those queries, and there's slightly longer time periods. But generally speaking, we are also seeing that there is heightened scrutiny when a merger notice is filed, and it is both. And I'd say that because the commission now is much more experienced, the kind of questions that you normally get from them are very refined. You can tell what their thought process is. You can tell that there is sophistication in the questioning style. And that's also because they've gotten a lot of experience in certain sectors, and they know what the problem statement could be in similar cases. Right? So the number of RFIs, the request for information, is also increasing, and the chances, and particularly if they're suspicious of them seeking your internal documents, is also something that we're seeing is on the rise. Um, so yeah, with that, I think this is all I have for you today. If you have any questions, I'm happy to answer. But Nidhi, back to you for now. Thank you.
Hi, Anisha. Thanks so much for that. I think that was a very insightful presentation. I hope our audience found it as helpful as I did. We've been getting a few questions, and I'm just mindful of time, but maybe we can pick up a quick few questions. You mentioned that the CCI can approve transactions with modifications. What does that mean and when does that occur? Typically, can you describe the nature of transactions that attract modifications with the CCI?
Sure, that's a good question, Nidhi. So the commission, when there's any transaction that goes to the commission for prior approval, there are three outcomes which are possible. One is the best outcome, which is that there is unconditional approval from the CCI, and this normally happens for large part of the transactions, which means no conditions imposed, obviously. The second is the commission finds a problem, and typically the cases where the commission finds a problem are those cases where the parties are competitors, their market shares on a combined basis are very high, the nature of the market is such that it is while regulated, it has limited number of people, limited number of players, and the concentration and the possibility of consumers or customers being able to switch become very low. So so these are cases which typically invite heightened CCI scrutiny and can also result in some sort of modifications, and these modifications could be divestitures, it could be behavioral commitments, it could be a mix of both. But once the problem statement has been identified or areas of concerns are identified, yeah, it is for either the parties or the commissions. Now, typically, if I just can go back to the statistics, there have been only 8 phase 2 cases in India so far. And in a phase 2, it is typically the CCI who tells what commitments it requires to alleviate its concerns. But if you're in a phase 1, then the law allows you or the parties to come up with any commitments that they believe should alleviate CCI's concerns, and the CCI can accept those, and if they do, then you have a phase 1 clearance. It's a conditional approval, but you still have a phase 1 clearance. And the third outcome is completely blocking of the deal, which is the deal is a no-go. The concentration is too high. The adverse impact is very, very palpable and very, very visible. And in those cases, the commission can block the deal. But the good news is that in India, we've not seen a single rejection of the deal in terms of blocking, and I think that's a good outcome for India as a country, because we're a burgeoning economy. We are doing well in business. It's and the commission also wants to be, not be seen as a naysayer, but a business facilitator. So I hope that answers the query, Nidhi.
Yes, it does. No, thank you for that. I think we have a related question on that, which is that most antitrust authorities prefer one sort of modification or remedy over the other. So, does the Indian authority also have a particular preference? And if the answer to that is yes, like why do you think that is the case?
So all authorities, I think, antitrust or non-antitrust, I would say, prefer something which is clean. You fix it in one go, is typically the preference. So Indian regulators no different. They also prefer a structural remedy. And when I say structural remedy, it means some sort of a clean divestment, which can be lasting, which can be sustainable. Because again, the presumption is that if you cut off one part of the business which can exist as an ecosystem on its own without its dependency on other businesses, then that's the cleanest way to sever it and also give it to another competitor or another player in the market who can then sustain it by itself. So the commission also prefers a structural remedy, but there are instances, for instance, in the L&T Schneider case, where divestment of plants was not possible because that plant was producing multiple units and multiple products, and divestment of plant therefore, and the problem statement was in respect of one such product and not all the products. So in those cases, the commission has recognized that certain sectors you can't just do a snip and move on, but you need to have a little more functional remedy that makes sure and balances the requirements of the combined parties to the transaction, plus is able to address the competition concerns that arise. But those behavioral remedies are, I would say, few and far between. Preference is always towards a structural remedy. It also ensures easier monitoring from the commission's perspective. Behavioral commitment uh, also makes things harder for the parties and for the commission, because you need to do ongoing monitoring, which also increases costs. So I think I would say both for parties and for the commission, a structural remedy wherever possible would just be more beneficial.
Got it. No, thank you for that. The next question we got was around the time that you were talking about the deal value threshold being introduced more recently, and the question we have is that generally it seems that India Inc. believed that the existing thresholds we had, which is in terms of asset and turnover, were adequate to regulate big M&A. So why has DVT really been introduced, and how does this impact M&A deals?
That's a brilliant question. So I think overall, just for some context setting, I think our existing thresholds were doing fairly well. But in the last 10 years, the way we interact with everybody, including how we do business, has changed materially. And tech has a strong focus on every aspect of our life. And what was being seen and witnessed very visibly is that there were a large number of tech deals, and there are a lot of these statistics which I can't remember now, but there was the statistics that the large tech companies have acquired so many smaller tech innovative players, and once they sort of acquired those sort of smaller tech innovators were no longer in existence, and this was being termed as killer acquisitions, because what you were doing is stifling innovation by simply acquiring any potential threat that you had to your own existence. So to be able to review these transactions, there was a lot of deliberation internationally to see how is it that we can catch these transactions, because clearly there is impact on the technology market, which is why the existing large tech players are only getting emboldened and getting more and more market power. The US always had this size of transaction threshold. Very recently, before India, Germany and Austria came up with this threshold, and then India, with its again excellent startup economy, also thought that perhaps Indian players are also facing that threat, and it is time that they also reinvent their toolkit to be able to review these sort of large tech transactions. And the reason why the existing thresholds were not being able to make the cut is because if you look at the threshold, 450 crores, 1250 crores of assets and turnover are really high values. A lot of listed companies in India also don't meet that threshold. And tech companies, which are usually asset light models or initially require a great amount of funding from investors, were hardly able to sort of make that meet those thresholds. Plus, the other theory was that in the conventional world, which are manufacturing driven or had very standardized, sorry, it's a long answer, but I'm just putting things in context here. um, what happens is that asset and turnover was earlier seen to be a good illustration or good representation of the market power. That is no longer the case. We are talking about large amounts of data being the new oil. We're talking about network effects. So the traditional theory that if you have high revenues, you are a big player, is gone for a toss. And that is another reason why it was believed that if you're paying enormous large dollars for acquisition of company, obviously you see some value which is not getting reflected in your turnover. And that is why you need to have some other tool to be able to review these transactions which are clearly having some sort of market impact. So I think this was the long answer, but the short answer is that there was an enforcement gap, particularly for mergers in the tech sector, and that is why this new law has come into place. And now both the DVT as well as the conventional thresholds are going to be run parallelly, and both have to be evaluated to see whether you need to take an approval from the commission.
Oh, super. Thanks so much for that long answer, but I think not a single word was wasted. All very, very useful to help us understand the context and narrative as to why, we're really seeing this change despite the asset and turnover thresholds being in vogue for a while. There are some more questions, but I am conscious of time. And so, like I said at the beginning, we will make sure we respond offline after the webinar. But thank you, Anisha, for your time. To me, some of the key takeaways really from today's webinar are that while the new law really introduces the deal value threshold test, it is mutually exclusive from the other tests. And so one should carefully assess the different thresholds and tests that are available to decide if the transaction is notifiable to the CCI. Simply, not meeting one test is not carte blanche from the others, and it's important to remember that, like Anisha mentioned at the beginning of this webinar as well. Um, Also equally important to me was that the prior approval of the CCI is required. The operative part being prior approval. This is a suspensory regime, and so parties cannot consummate the transaction until the CCI approval is obtained. So it's very important to have your eyes on that and factor that into deal timelines and processes. Of course, the green channel route continues to be an exemption where deemed approval is available. But like we discussed, we need to carefully establish that there are no overlaps and that you actually qualify for green channel approval. And again, your documents need to all sync up and make sure that different positions are not taken in your definitives versus your internal documents. Like Anisha mentioned, given the boom that we're seeing of digital technology and advancement generally of tech in traditional businesses in India, it has not left our regulators untouched. Our regulators are also using digital and technological advancements to decide and decipher whether there were certain transactions that were notifiable but otherwise did not come before them for notification. So, press releases, statements that are put out on websites of acquirer companies or LinkedIn profile updates and things like that are also carefully being looked at now by the Commission. So all of that needs to sort of sync from the same hymn sheet, and I think that's a key takeaway from today's webinar. So thank you for bringing that to our attention. Before closing, I would like to ask each of you to respond to the poll slide on your screen. Um, if you could move to the next slide, please. Thank you. We take this very seriously as part of our continuous improvement program. And we'd love to hear from you so we can continue to make our webinars to you better while keeping in mind specific feedback that you share with us here today. Thank you everyone who has participated in the poll. Finally, I would like to thank Anisha for sharing her expertise and experience with us today. You were simply outstanding. Thank you so much. Also, thank you to our audience for your attention and your questions. I hope you found the webinar interesting and a worthwhile investment of your time. We thoroughly enjoyed bringing it to you. After the webinar, we will send to you a copy of today's presentation materials, summary notes, and a link to the webinar recording. You will also separately receive a request for your feedback on this webinar. It will not take more than a minute of your time. So please do take the time to send us your feedback. Comments, criticism, and even compliments are welcome. If you are interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact us. Our contact information is on this slide here on your screen. Thank you for your attendance today, and we look forward to being with you again.